apologize for that.
It's all right. When you're ready.
Here is third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all of my constitutional rights, mostly the First, the Sixth, and the 14th Amendments.
Thank you. The record should reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is wearing his jail attire this morning. I do want to make a record that at 8:46 p.m. yesterday, I did swear in 2 additional sheriff's deputies who would be working with our jurors through the overnight or third shift hours. I did administer the same oath that was administered to all the other bailiffs yesterday evening. Then, of course, we are open, and the jurors are here, and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post, that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the Sheriff's Department is looking into that as well, but it's my understanding, based on news reports, that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post. So I just wanted to put that on the record. And if and when, or I should say when, the investigation is completed, I will assure the parties that you will be provided with that information.
So,
go ahead.
So it's being called a prank?
Per the Reddit post itself, yes.
So we don't have any idea if that's a fact, though, right?
You're correct. I'm just putting on the record the additional information that's been reported on. And then again, once the Sheriff's Department concludes their investigation, it will be turned over to the parties. So at this point, until there's a question or a verdict, courtroom will remain open. I'm going to be working in my office on other things, and will be available, of course, if there are any questions or if a verdict is reached. So notify the parties.
Judge.
Yes.
Go ahead.
No.
Go ahead.
I'm still very concerned about this whole Reddit thing after having the chance to fully read it and look at some of the language that's in it. It's very concerning.
That's why there's an investigation, sir. It's anytime there's an allegation that the integrity of this judicial process has been compromised, especially with a juror, I take that incredibly seriously, which is why I turned it over to the Sheriff's Department.
I would like Your Honor to, if it pleases the court, and if it pleases Your Honor, I would like to look at some alternatives. If I may bring up the in regards to the language, I also want to state that for the record, this did not come about from the prosecution side, from the defense's side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that I was the last one to learn of this information that had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
It was shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state the record. Your
I can
Honor.
address that for you right now if you would like.
Yeah. If it pleases you, Your Honor, I would like to request some alternatives to this issue.
What's your specific request?
My specific request would be to look into a mistrial and also any alternatives along those lines, short of that or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody. And as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
One being United States versus Perez, 22 U.S. 579, and that specifically, I think it's referenced because that one is pretty old in itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references in regards to issues similar to things like this when it comes into play. And it specifically points to trial judge's discretion. And I think that's kind of like the leading one. Also, I looked at Brown versus Rushton, 572 F.3D 198, which speaks to the language is basically, it speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature. Also, United States versus Bates. That's BATES. 917 F2D 388. And that speaks of potential for an impartial verdict. Specifically, it says along the lines of impartial verdict, if an impartial verdict can be reached, or if a verdict of conviction could be reached but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington, 434 U.S. 497, and that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury which may be tainted by bias, and I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing to do with this, and certainly you, Your Honor, had nothing to do with this. But just for the concern factor, the language it's pretty clear that this, if not directly came from a juror who sits on this panel, it came from someone who sits in this courtroom every single day. The language, it directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning. Extremely concerning. And then going back to some of these case laws that I cited, it talks about something to the effect of the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it. Obviously, I'm not educated in a lot of the laws in itself, but how I was interpreting it, this is definitely a concerning issue. It's definitely something that I would request Your Honor to take a long look at. Look at some options. Look at some alternatives. Then those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this. If anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here in these case laws and
What's the request, though, that you're making based upon the case law that you cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You said request for
relief.
Relief.
And what are you asking me to do based upon the information that the limited information we have about the Reddit post and this trial?
I guess my request would be, because of the concern of this, to look at a mistrial, or at the very least a discharge of the jury at this time, so this can be resolved. This is alarming, to say the least. This post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different. I don't know the extent of this website. I don't know who. Well, I think the name of the person who sent the who alerted the clerk, of course, to this post. I think his name is in the email. But then that even begs the question of, how did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions, and I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming. It's very alarming. And if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later. This is very concerning.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start and that the original poster didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that, like you just stated, it's an investigation going on. And if there's an investigation, then that clearly says that something is amiss. We have 15. We have 15 jurors. There's still too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue is put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever it is, thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think, common sense would tell you that this is someone who's very close to the case, whether they were intending to be funny, whether they were intending to try to prank the court or anything like that. We don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. They point to certain language in the case. They make references to saying when we were in the room. They got certain feelings from where they specifically refer to themselves and a group. That would be we, plural. They say, and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is if this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it. This is clearly someone with intimate knowledge of the case and what's going on. Clearly. There's no other way to interpret this. You can tell by what they're laying out in the language that they're speaking with, that this is clearly someone close to the case. And because of that, it still has to be, I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation? For all we know, what if this turns up that it was someone on the jury, or what if it turns out that more people are involved in it than just whoever this anonymous person was who left the post. It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks, and even in court dates leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out? I mean, it begs so many questions. It's too uncertain. It's too concerning, and it's too alarming. It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let them." No, this there has to be some type of alternatives, and something has to be done. Something, and if that's a mistrial, if that's discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other options that could come into play. They deserve to at least be looked at, if anything, to protect the integrity of the trial. I find it very hard to believe that this close to the trial being over, and all of a sudden these issues are being raised. So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
Well, let me address your concerns, sir. I cannot make conclusions at this point about whether this is legitimate or a prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement, because it is very serious if the integrity of these proceedings were to be put at issue by a juror. I'd remind you, though, every single day these jurors were read the bulk of jury instruction 50. They all took an oath, and I have no reason to doubt that they would violate that oath at this time. So I took and I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury, and I wasn't going to delay the proceedings because it was so speculative at that point and remains speculative at this point. As you know, the case went to the jury. I brought this up. I waited about a half an hour once the case went to the jury. Frankly, we had had a long day. I wanted to get a bit to eat, and then I wanted to come back out and make a record of what I had. Once again, the forensic unit with the Sheriff's Department has taken lead of this investigation. I'm not a part of that investigation. Law enforcement will handle it. From my perspective, not only did the Clerk of Court's office receive emails regarding this, it sounds like the District Attorney received emails. I may have even gotten one, I don't remember the time, it was later, regarding the post. Frankly, people figure out my email all the time. It was not solicited by me in any way, and I did not respond to it, and I simply forwarded that email onto law enforcement. So it's pretty clear to me that a lot of people have access to Reddit. I personally am not a user of Reddit, so I don't know the ins and outs of it, other than it is a social media site where people can create accounts and post, and there can be like chat rooms, for example, or just various, as this is called, subreddits. And at this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now, the record is speculative. There are no facts to support a mistrial or discharging the jury. I trust the parties will continue in their own independent investigations, that you will continue reviewing case law, make whatever requests that you deem appropriate. I certainly will take time to look at the cases you have cited, to see if there's anything based upon the requests that you have made that I would need to further review. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury. That is how I will address it at this point. I know the state, I believe, wanted to address something else. I'm not sure if that was it, but you had deferred to Mr. Brooks, so go ahead. Is there anything you want me to address or at least bring to the court's attention at this time?
Just a minor point, Your Honor. You had noted the defendant is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes, and he declined, so I just wanted that on the record. There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he should be in civilian clothes if that occurs, if he chooses to.
It's a good point to bring up. It is possible the jury would need to be brought out if there is any question that I need to answer on the record. If for some reason the technology were not to be working appropriately when videos or other evidence are displayed to them. And so it is possible that the jury would need to come out. Of course, they'll come out if and when a verdict is reached. So I would certainly give you the opportunity, sir, if you want to change into the street clothes, that I would certainly direct the Sheriff's Department to make that available for you, should you choose.
Isn't it my choice?
Yes, it is.
So why do I need to be in street clothes? Why does that need to be on the record? That
your choice should be placed on the record, sir.
If not, I was offered to be in street clothes. If I made it the choice.
Do you dispute that, sir?
Yes, I dispute it because it's my choice.
Well, no. Do you dispute that you were given the choice this morning?
At this point, there's no reason why that should be on the record. That if I was not offered street clothes, what relevancy does that have to?
Could have potential relevancy later on if
Why?
you were to challenge that you and claim that you were required to wear your jail uniform or jail attire. You're not required. This is a trial. You have the right to wear street clothes, and I will certainly provide that opportunity should you wish to change at any point in time. But what you're telling me is it's your choice to be in jail attire. I'll respect that choice, of course.
So why does that need to be stated for the record?
I just indicated why, sir. So
I don't see the relevancy of it.
all right. At this point, unless there are any further issues, I am going to go back into my office. The courtroom will remain open, and we'll let you know when the jury communicates with us, either about a question or verdicts.
There is something that needs to be addressed. Subject matter jurisdiction.
The court declines that. I'm stepping off.
Why hasn't it been proven on the record yet? And I
And State versus Brooks appearances are as they were before. I would make just one note that Mr. Brooks is now present in a suit. And I will also advise that at 9:43 a.m. this morning, I was advised that the jury had reached verdicts in this matter. And without anything further, I'll have the jury brought out.
Your Honor, I don't consent to being called that name and would like to address subject matter jurisdiction for the record that has yet to be proven.
Your objections are noted. I will not be addressing subject matter jurisdiction. Please bring the jury out.
Would it be proven for the record, Your Honor?
Just a reminder to everyone that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read and refrain from audible responses. Any disruptions may result in removal from the courtroom.
Your Honor, is that a tacit agreement not to address subject matter jurisdiction for the record?
Jury's coming in. All rise, please.
I respectfully object to that ruling, Your Honor, and request the legal reconsideration of your ruling for the record.
Your requests are noted, sir. I will not be addressing that further.
For the record, may I respectfully reject that ruling and take exception to that ruling, Your Honor? Is that a tacit agreement and a judicial determination that you don't have to answer that question as a public servant, Your Honor? For the record, may I request the legal or factual basis for your ruling, Your Honor?
It might have been a false alarm.
For the record, may I respectfully
Would be
request
yours.
a written judicial finding of fact and conclusion of
No,
law
it was
on this
something.
issue, Your Honor?
All your requests are noted for the record. They all are denied, sir. All rise. Jury's coming in.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor?
Denied.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Denied.
Based on what law or fact, Your Honor? Is that a tacit agreement that you don't have to answer that question? For the record, Your Honor, as a public servant? You don't have to address admiralty law or common law if this court is operating under admiralty law?
I will not be addressing any of those issues, sir.
Respectfully
Thank you, everyone.
object,
Please
Your
be
Honor.
seated. Ladies and gentlemen of the jury, have you picked one among you to be the foreperson? All right, and I see it's juror number 11. Have you reached verdicts on all 76 counts?
Yes.
All right, would you please hand all of the forms to the bailiff?
Your Honor, seeing as that we've reached a verdict, is it necessary that I have these shock devices on my ankles?
confirm that there are 76 signed verdicts and 76 unsigned verdicts, which would be what I would expect. All right, I will read each one into the record. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. Dated this 26th day of October 2022, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 7 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 8 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 10 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 11 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 12 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 13 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 14 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 15 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 16 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant guilty of first-degree recklessly endangering safety as charged in count 17 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 18 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 19 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 20 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 21 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 22 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 23 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 24 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 25 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 26 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 27 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 28 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer,